As both the U.S. Securities and Exchange Commission and Ripple chose to go to court in the Second Circuit Court of Appeals, large amounts of XRP were bought by institutional buyers. People who invest in XRP were more hopeful about a big rise in the price in the future after Ripple recently beat the SEC in both a district court and a circuit court. A report from CoinShare on October 14th says that institutional buyers bought XRP worth $1.1 million last week. It was $0.3 million the week before. So while Ripple and the USSC got ready for their cases in the circuit court, buying activity went up every week for the first time in 266 weeks. Given that investors are still hopeful about an up, it's no surprise that digital asset investment products saw net gains of $407 million in just 1 week. Investors didn't care that CPI and PPI prices in the US were going up because they wanted to keep buying on dips. XRP's price has gone up by almost 4 times in the last day, and it is now worth $0.55. The 24-hour low is $0.525 and the 24-hour high is 550 cents. Also, the number of trades has gone up by 60% in the last day, which shows that buyers are interested. Due to the big news about XRP, open interest in XRP futures has grown by more than 6 times in the last day. It is now $149 billion, up $766 million from before. During the remedies part, the USSCC challenged Judge Torres on a $125 million fine instead of the nearly $2 billion in sanctions the agency had asked for. This week is the last day to send in Form C and D, which have all the information about the appeal on them. Fans of cryptocurrencies are mad at the SEC for filing an appeal and making the case last longer. In the meantime, Ripple filed a notice of cross-appeal to disagree with the SEC's illogical appeal of Judge Torres' ruling. As Brad Garlinghouse, CEO of Ripple, put it, the cross-appeal will seal the SEC's fate and finally put an end to the regulation by enforcement agenda by the agency under Chair Gary Gensler, Mark Fagel, and James Farrell, who used to work as lawyers for the SEC, say that the SEC will challenge both secondary and programmatic trades. In her important summary ruling from last year, Judge Torres did not talk about how the U.S. Securities and Exchange Commission (SEC) has been suing and looking into cryptocurrency businesses for transactions on the secondary market. Additionally, Benamiel sued the USC for saying that XRP is a guarantee even though the court said it wasn't. It was also questioned by lawyer Bill Morgan why the SEC classified the futures as contracts for financial futures. He criticized the regulatory enforcement's lack of consistency by comparing XRP to similar events with Ethereum, where the SEC had earlier said there were no problems with the futures contracts. Before we go ahead with our plans, the SEC could appeal the Ripple court's ruling. Mark Fagel, who used to work for the Securities and Exchange Commission, has made guesses about a recent court decision about the private sales of XRP in the Ripple case. Fagel has given hints that the SEC might think about reviewing the order. This talk comes after a decision that made it clear that initial sales of XRP do not count as securities. Because of what Fagel said, it's more likely that the SEC will change how it views deals on the secondary market. Will the SEC go after secondhand sales of XRP? Phil brought up the idea that the Securities and Exchange Commission could still take action against secondary sales in the future, even if the original transactions turned out not to be securities. The second CC appeal is about selling XRP on the secondary market, which was not directly talked about in the most recent court order. If another company decides to sell XRP as a security, they can still file a lawsuit even though Ripple made the choice. So the SEC will keep checking to see if XRP is a security. Bill Morgan is a lawyer. The move by the Securities and Exchange Commission to treat binomial XRP futures contracts as securities has made Morgan very worried. In what ways might the field be affected by the law? In his comments, he talked about the problems with the CC's regulatory framework, especially with how they handle Ethereum. This is what Morgan said: such arbitrary enforcement is unacceptable to me. It doesn't come as a surprise to me that Bitcoin and Ethereum are getting a lot of attention at the moment. Comments like these about the SEC's more recent rules show that the business world is becoming more worried about how they are enforced. Ripple's lawyers are smartly going after a cross-appeal in answer to general claims about XRP sales. They also say that the Commodities Futures Trading Commission, not the Securities and Exchange Commission, will control XRP. This shows how important these talks are for figuring out how XRP will be regulated in the future when it comes to secondary XRP sales. The SEC might be able to hear the case. The regulatory groups are still looking into how safe XRP is. There are big worries about how the SEC enforces the law in different ways. One goal of Ripple's approach is to rethink how regulators should keep an eye on XRP. There is a lot of volatility in the cryptocurrency markets right now. This is shown by Rumors that the SEC might file an appeal in the Ripple case to better handle how complicated it is to classify crypto assets. People who have an interest in the acts of the SEC are eagerly waiting for legal frameworks that make things clear. Johnny Deaton, who backs people who own XRP tokens, has raised major concerns. He used $75,000 of his own money to protect the 75,000 people who owned XRP in court. Datatton brought to light more wrongdoing by the SEC. Federal judges have said that XRP is not a security, which backs up Dayton's long-held view. This decision hurts the SEC's image and makes people question whether the agency should still be in charge of watching over the Securities and Exchange Commission. The SEC sees XRP as a security no matter what the court says about this gap. This made people question the SEC's credibility and showed a concerning relationship between the SEC and Senator Elizabeth Warren's office before a Senate hearing. A Freedom of Information Act request showed emails between Warren's office and Securities and Exchange Commission Chairman Gary Gensler, which raised ethical concerns about the relationship between government agencies and political parties. The emails show that Warren workers asked Gensler what he thought about how Bitcoin will affect financial inclusion. The Securities and Exchange Commission is trying to claim joint authority over Bitnomial LLC's contracts for XRP futures. The company has sued the SEC to stop this. Bitnomial's comment shows that it thinks the CFT is the only one with the power to regulate these contracts and that the SEC's claim of jurisdiction is therefore an unnecessary overreach. Bitnomial is about to start the first physically deliverable XRP futures, which makes this topic even more important right now. The CFT self-certified these futures on August 9, 2024. The CEO of Ripple, Brad Garlinghouse, is the lead lawyer for Bit and the Emil Derivatives Exchange, which is based in Chicago. They are suing the U.S. Securities and Exchange Commission and the Commission for what most people think is too much government involvement in the economy. What it sees as an increasing regulatory burden from the Securities and Exchange Commission, the Seatbit nominal provider of XRP futures contracts, is actively seeking a declaration in Illinois. There has been a long-running dispute between Ripple, the company that makes the XRP coin, and the Securities and Exchange Commission. Ripple says that XRP should be considered a security, which the SEC doesn't like. After a recent court ruling that said XRP does not meet the requirements for securities, people in the cryptocurrency community are worried that the agency might go too far with its rules. Even though the law has been made clearer, the agency is still trying to take control of XRP and other digital assets. There is no doubt that Garlinghouse has spoken out against the Securities and Exchange Commission (CU). He quickly backed Biden-Mild's case against X, though, accusing the Securities and Exchange Commission of being a law-breaking organization that doesn't care about the law. He said that the SEC is ignoring the court's decision that XRP is not an asset. Ripple's CEO said that his company would be closely following the developments in the Bottom CC lawsuit and looking into possible legal options to fight what he sees as too much action being taken by the agency because of Ripple's ongoing legal battle with the Securities and Exchange Commission.